In a recent medical malpractice case, my client was being questioned by the attorney who represents the doctor in this medical malpractice case. The injuries were so bad and so horrendous that the defense attorney barely touched on questions concerning my client's current injuries and the problems that he has today. At the end of questioning, is it okay for me to go ahead and ask my client questions to elaborate and explain and expand on the type of problems and limitations and disabilities he has because of the injuries he suffered from this careless doctor? Would you like to know the answer? Come join me for a walk through the neighborhood as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. A deposition is a question and answer session that's given under oath. The opposing attorney, the lawyer who represents the doctors and the hospital staff, will have an opportunity to question my client, the injured patient, for hours on end, all about the problems that he has now, about the limitations, the restrictions, the disabilities, about the facts leading up to the malpractice, about the event itself, and what problems he has now and what treatment he's received, and just go on and on. The defense lawyer will also be able to ask questions about my client's history, his past medical history, his past surgical history, his past lawsuit history, and many other questions that ultimately you will see have very little to do with the actual claims involved in the case. Okay, so now my client's injuries in this particular medical malpractice case were clear-cut. They were obvious. It was so obvious that as a result of the malpractice, my client needed to be hospitalized for months, and following his hospitalization, he needed months of rehabilitation. And following his return home, he needed a visiting nurse to come to his home for months so that they could help him nurse him back to health. And now, these injuries were clear-cut, they were documented very well. And during the course of the deposition, the opposing lawyer spent many hours going through my client's background. He spent many hours asking my client about his past medical history and what problems he had in the past. And then when it came time to asking about his current limitations and disabilities, he asked only a few questions. He only wanted to touch upon certain things to identify what issues he has now. That is something critically important for the defense. Why? Because they need to understand what problems my client, the injured patient, has currently as a result of the improper care that he received from the doctor and the hospital staff. Now, why did I ask the question at the beginning of this video that if the attorney barely touches on my client's damages, do I have the ability to go ahead and ask my own client questions when the defense lawyer is done asking questions of my client? And the answer is, yes, I do. You see, I may feel that the defense has done an inadequate job of bringing out the extent of my client's injuries and does not have a full picture and full understanding of what problems and limitations and disabilities my client has now suffered and has experienced and will experience in the future. If I feel that's true, now I will have the ability to go ahead and ask my client open-ended questions. They're like direct examination questions where I am asking my client to tell me who, what, where, how, when, and to explain further. In almost every instance, the defense lawyer will likely object to my range of questioning. Why? Because he doesn't want me putting this information on the record. He doesn't want this recorded. He wants to limit the answers to my client's questions only to the questions that he was asking. And he's concerned that if I am going ahead and now questioning my own client, it clearly is going to impair his defense of the case, and it's going to improve my client's damages and the value of our case. And that's the entire point, because the defense should be doing everything possible, in my opinion, to learn the true extent of my client's injuries. You know, it's one thing to read the documents, to read the claims of what was done wrong, to read about the injuries that we are claiming my client suffered, and to see in the treating records my client's doctors who treated him what exactly he complained of and what problems he has now. But it's a totally different thing to ask a person in person or to ask them over a Zoom video call to explain to me what problems and limitations you have now. How is your daily activity restricted, or how has it changed from before this incident occurred? What are those things you can do now with difficulty or do with pain? And what limitations do you have, and what things can you do without pain? It's critically important, at least from my opinion, for the defense to learn all this detailed information. And they use that to report back to their principals so they have a better understanding of what problems and complaints and injuries my client has suffered as a result of the doctor's carelessness. And they do that to assess risk of going to trial down the road. And it is very important, and they also do that to assess the value of my client's case. Now, if the defense attorney from a strategic standpoint decides, you know what, I don't want this injured patient to go ahead and run on and give me run-on explanations for 10 or 15 minutes explaining all the problems that he has now, because clearly that will increase and boost the value of his case. Plus, if they go ahead and try and get your case thrown out at the end of the discovery phase of your lawsuit, there won't be much information in there to establish that you suffered significant harm and injury as a result of the doctor's care and treatment. In that instance, they will use their expert to show that whatever injuries you are claiming clearly are inconsistent with what you have testified to and what your injuries really are. So let's go back to the question I raised in the title of this video. If I feel that the defense attorney has not done a thorough job of asking my client, the injured patient, questions about what damages he has and his restrictions and limitations, I most certainly will go ahead and ask follow-up questions. Mr. Jones, I know you were asked questions about some of your limitations and injuries. Can you tell me further and explain further what problems you have currently as a result of these injuries? And now he's going to go ahead and give a long-winded explanation explaining in detail those injuries that he did in fact suffer. And is that it? Do I just ask one question? In all likelihood, no. I have many follow-up questions because I want him to be able to articulate, I want him to be able to explain in detail those problems and limitations that he has. And then I will simply stop. Now, at that point, if the defense lawyer has more questions that he wants to follow up on to those answers, can he do so? Yes, of course he can. Because now certain information has come to light that he didn't learn about before, and he can certainly ask additional follow-up questions. So why is this important, and why do I share this with you? I share it with you because this happens from time to time, where a defense lawyer, I find that a defense lawyer may, for a very strategic reason, decide not to ask detailed, thorough questions about my client's injuries. In that instance, I most certainly will ask questions so that the defense lawyer understands the full extent of my client's injuries and be able to present a thorough picture to his principals so that they can better understand what effect these injuries have had on my client and how it's going to affect him into the future. And I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you have not yet started a lawsuit but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.